One of them was for 1,000 and something, and when I called there, that one they said was a zero balance on that one.
Yeah, and I think there was a couple others too, but I'd have to go through them all and look at them. I don't know if I've got them all in one place or not, but if you have the list of bills that you think are outstanding, or at least any notices that you got, I'm happy to call those people and see what we can do about getting it resolved. But still, again, it's not like we're going to decide to pay, $10,000 or $15,000 to settle the whole thing. Even whether or not the bills have been paid, because it's not really our issue. It's not your bills or your medical treatment. It's more on the liability side of things.
What? Could you repeat that again?
I just saying we're not. I don't know that we're going to be able to resolve it even if I call those people. But I'm happy to. I will. I'll give them a call and try to negotiate or lower those bills and see what we can do to make an agreement to get rid of them based on a resolution. Because I know that like what you were telling us before was, I don't know what it's going to take to solve those bills, and then I said, you don't know anything on those medical bills. $4,000. I thought that was good. And if it's not, then we weren't in the same realm of what we were talking about. So we had a miscommunication. Yes.
Yeah, definitely a miscommunication there because when I found out they are putting this stuff on my credit, that's when I guess I was talking to Charlotte to try to get it squared away, and I was just trying.
Who's Charlotte?
Say again?
Who's Charlotte?
Charlotte is the female that dealt with you in the beginning at the Gallagher Bassett service company, the insurance for McDonald's.
Oh, I got you. Okay,
Yeah. Yeah. There's a video. There's a video up about that conversation with her.
If you want to email me the bills and phone number of who to talk to in each bill, I'm happy to do it.
Okay, as a lawyer, you should have been on top of the stuff that I've already sent you. You were able to pull a picture up in front of a judge that I screenshotted from a video without even getting in touch with me on that. So you should be able to. You should be able to go look at that judicial notice, the last one I filed, and you'll see all the bills there. That's in all my judicial notice. I filed all the bills there.
Okay, so there's nothing else
Other than what?
other than what I have in that document.
The far as the bills go, those are the bills that they're putting on my credit. They're damaging my credit.
Okay, maybe send me a copy of your credit report and I'll know which bills they are. Because there are a lot of those that have already been resolved. That's what I'm saying.
No. That's not the truth. A lot of the small one for the one I just checked on, which was 1,000 or something. That one, the balance they said was 0. The one for close to $7,000, that was the other one I called on, and she said that one's still pending.
Okay, send me. So it's pending with your insurance, and it's going to get paid off. It just hasn't. The insurance hasn't paid it off yet. So what I'm asking.
The thing is, why would a creditor be contacting me if it was going to get paid off? This already been pushed over to the creditors. That's why they're sending me bills. The creditors are sending me bills. So it ain't pending to be paid off. They're looking for it to be paid off by me.
Documents I have the creditors stuff in it.
Say again?
Do the documents that I have include the notices from the creditors?
Yes, it is all in there. Everything is from the hospital statements to the people that the hospital sent the bills to them contacting me. All that's in there.
Okay, so I only need to call the bill that's $7,000.
That was just the two that I called that day. There's small ones in there that I didn't even bother with. So those little knickknacks of $100 and $200 or $300 in here, I didn't even bother to call on those. That main one there that I was looking at, she said it's still pending. And then so I did on what it's worth on the emotional stress. In 2005, the the minimum request to settle or emotional distress case was $85,000. That's 2005. I haven't looked up what it is for 2020.
I don't know what you're looking at, but it doesn't. There's no such thing.
It's called what it's worth. Your
Yeah,
your injuries, what it's worth. This is what it's called. You can go to the law library and they have a book on it.
Imagine if every case was worth $85,000.
That's you know what. Like I said, that's why they have juries. So I'm not going to get into debate with you on this and that.
Yeah, no. I mean, that what you're saying is that every case has a minimum base of $85,000.
That isn't what I said. What I said is what I said.
Okay, well, is that what you mean? I guess is that what you mean, that every case has a base of $85,000?
I told you what I discovered on the internet in 2005. What they're saying it was going for. That's all I said.
There's all kinds of stuff on the internet, you know. I mean, and I love it when my kids say, "Oh yeah, it's true. I found it on the internet." I said, "Oh, it's on the internet, and that's true," you know. So I don't know what it is you're looking at. Obviously, I think if your case was $85,000, I don't know if you're aware of it.
You're breaking up. I don't know if you're in the kitchen or in the bathroom. You're breaking up.
Yeah. That's all right. I'll send me the bills that you want me to follow up on. Because I'm going to follow up, like you said, on the chunk change ones. But any of them that you want me to make a phone call, just tell me how which bill that is, and then I will call.
Could you repeat yourself? Like I said, you're breaking up.
Yeah. Send me an email.
The emails forced to you guys don't work. So the thing is, best I can tell you is look up the judicial notice under the document. The last one I filed, all the bills, they haven't changed none. They're still there.
How about if I send you a phone that all it does is allow you to email me?
Say again?
I'm gonna do a phone, one of those burner phones that allows you to only email me.
You're really breaking up real bad there.
Yeah.
Yeah.
All right. Well, I guess we can't talk on the phone either.
Well, I mean, I don't know. Yeah, you're really breaking up real bad there.
Yeah, I'm getting you loud and clear, so my reception's good.
Well, I don't know what to tell you. Maybe I'm in a bad area myself then.
Yeah. Well, call me back when you think you're in a good area.
Like I said, all the bills have been filed with the court, and the same copy the court has is the same copy you have. So I don't understand what would be the problem for you to look through the bills and call the phone numbers that's on there.
Well, you told me that you called one of those places.
To be more exact, I told you I called two. I told you I called the first one, and they said that one was a 0-0 balance, and I told you I called the second one. The one was close to 7,000. So if you listen carefully, I told you I called two places.
Okay. So then what I said was, send me those two so I know which ones I'm dealing with, and I won't call the one that had a zero balance, but I'll call the other one that had the balance you wanted me to call about. I'm not going to call on all the other little ones, just like you didn't call on all the other little ones.
Listen, you have a copy already. Everything I gave you, I gave to the court, and I have a copy of it. So I'm not finna run back down to FedEx, make more copies, and then resend them to you. You already have them.
Well, just email me the bill and the person's name and number, and I'll call them.
I gave that to Edwin.
I'm just asking you. I don't know where Edwin's stuff is. I don't know if he wrote it down. I don't know what happened to it. Was it in an email? You could just forward that email.
Okay, so what I would say is look through the paperwork, and the one closest to 7,000, it has a phone number on it.
Yeah,
it doesn't seem to me like you really want to.
I'm willing to do you the favor and the courtesy and make that phone call. You just got to tell me who to call and which bill it is.
Okay, so look through the paperwork. That's what lawyers do, right? It's called due diligence.
Yeah, it is.
So I'm pretty sure as a lawyer, if you really wanted to go through the bills and find it, I'm sure you could.
I don't know. I might get the wrong one.
Anyone that I put inside that document is not the wrong one. They're all there.
I know, but you just told me that you only called on 2 of them, and one of them was zero balance. The other one, it hadn't been received or it was in processing.
Okay.
So I want to call the one. I want to call the one that you called that said it was in processing. I want to call the same number you called, and I'm not going to go dig through the file and look for that to do you a favor.
You're not doing me a favor. You're trying to settle a case for your client is what you're trying to do. You're trying to correct something that has been done wrong by your client. So it ain't like you're doing me a favor. That's why I filed the lawsuit.
Yeah, see, we're heading in the wrong direction because that's not what I'm doing. I don't want you to think that's what I'm doing because that's not what I'm doing.
Okay, so like I said, you already have a copy of it. You can either go look for it and do your due diligence and call up on them, or you can just wait for the Second Amendment complaint to come down.
Okay.
So, I've already...
Send me the amended complaint when you're done with it and file it with the court so they can have a copy of it too.
That's what I've already done.
Okay. All right, it's already filed with the court?
I don't know if the clerk got it yet, but it's in that direction.
Did you take it in and file it?
No, I didn't take it in. You can't go into the courthouse and file anything right now.
All right, so you just mail it in to them?
Yeah, you can do it that way.
Is that how you did it?
Say again?
Is that how you did it?
I put it in their Dropbox. Put it that way.
Okay. Okay, didn't you mail me a copy?
Yes, I did send you a copy. Every time I file something with the court, it's my due diligence to send you a copy of everything I file in the court. You should know that by now.
Yeah, I'm still learning law. You know, they say you practice law. I don't think you really get good at it. So I'm still learning a lot of things. And let's see what you can teach me. It'll be a good experience for me. As far as when did you mail the copy of when did you file the complaint?
What do you mean?
When did you file it? You said you dropped it off the Dropbox?
So, no, it hasn't been filed yet.
Oh, you just told me you dropped it off the Dropbox.
So it has not been filed with the court yet.
Well, if you dropped it in the Dropbox, that's filed.
I tried to go and file it, but the courts wouldn't allow me to file it because you have to set up an appointment to come into the courthouse.
Okay. And then as far as mailing me a copy, you have already mailed me a copy?
That would be correct.
And when did you mail that?
That one would be going out tonight or either in the morning.
So you haven't already mailed me a copy?
It's already been packaged and ready to be filed, or ready to be in process.
All right. Well, send that stuff to me when you're done with it, and we'll take it from there.
Sounds good.
Yeah. If you want to get back to talking where we were, I'm happy to do that, but they're not going to consider anything beyond and above that. Okay?
Look, you guys giving me hell just trying to get the credit thing cleared up. So I already know that there's, it goes in one ear and out the other with you guys. So that's why that's why they have juries.
And
so when you have people that you can't come to an agreement with, then there's the jury.
That's just it. There's a judge, and behind his bench, he's got this sign, and he says it's okay to go to trial. It just means you guys couldn't agree on something, and it may be that we can't agree. So all we can do then, rather than arguing back and forth, is to say, all right, well, we'll agree to disagree on that fact, and let's move on.
That sounds about right.
Yeah. But like I said, if you ever get back down into the realm of where we were talking, I'm ready to stand ready, willing, and able to continue to discuss a resolution with you. And I will, look forward to getting the First Amendment complaint. We'll take a look at that, see how that works out, and I guess we'll see the judge next in October or something like that.
So are you guys working on getting me a copy of the surveillance video, or you can give a copy to the court? What happened with that?
I don't give a copy to the court, and you have to do your job as the plaintiff to get it from us during the litigation process.
Okay, so I filed paperwork with you guys requesting that, and you guys still not have given me a copy. I even did a subpoena, which
then you need to file a motion with the court to force me to give it to you.
Oh, so I have to force you. Okay, I see. I have to force you to get it.
If you have sent me a request for it that I'm supposed to respond to, then if I don't, then this is what will happen when all of our discovery to you. Say, he hasn't responded, he hasn't given us stuff, and we'll file a motion, and then the court will take it up and go, okay, Mr. Moss, you're right, you get this. Mr. Moss, you're wrong, you don't get that. Mr. Moss, you can not get any of this, or Mr. Moss, you get it all. Who knows? But that's what the process is like.
Okay, so I've done that, and I've done it requesting a copy of the surveillance video. I also served subpoenas on that, and you guys still have not done it. And Charlotte, I do have a conversation with Charlotte saying that she received the subpoena, and she preserved it, and all of that.
When did you have that conversation?
That was probably June. I'm not sure about the dates, but it was in 2018.
All right. Well, I don't know that there's any. If you got a copy of the conversation, let me know. If there's
that'll be in the Second Amendment complaint. I've already had it transcribed.
If there's letters about it or emails about it and anything.
Yeah, it's been transcribed, and you guys will be getting a copy attached to the Second Amendment complaint. It's already been certified and it's been transcribed, and she clearly says that she's considering the first-degree burn to the hand for the lid coming off of the coffee cup, and she also said she received a subpoena for the surveillance video.
What I would recommend is for you to get yourself a lawyer. I highly recommend that.
I don't trust lawyers.
Yeah. Well, be careful, because that judge is a lawyer.
I'm aware that judges are lawyers. That's all they are, is lawyers on the bench who wears a robe. So they have to have the same license as a lawyer. They have to they're bound by the same license.
Yeah. All right. Well, let's agree to talk again. I'll call you if I receive. If you send me the name, phone number, and the name of the bill that you want me to check in on for you, I'm happy to do that. And also, if you send me the
it's been 2.5 years already, and you guys did nothing but sit on your hands on this. So what makes you think that I believe you're ready to do something about it now?
You don't need to. Go get somebody to get my hands off under my butt, or whatever it is you're trying to insinuate. But you don't have to believe a word I say. You don't have to agree to anything I say. But I can tell you, I'm not throwing a bunch of hogwash at you at all. And if you had a lawyer that could listen to what I'm saying, he would say he understands and agrees with everything I say. As I think the judge will. So that's all I can tell you. I don't expect you to believe everything I say or cower away. But truth of the matter is I may not be right on everything, but 95% of what I'm telling you is true. Dead on. If there's a mistake in there, I won't claim 100%, because there could be a little error, and that's why you need to have your own lawyer, because if I make an error on something that is critical, then I wouldn't want you to rely on.
So I should chalk this conversation up as a meet and confer?
Yeah, I'll send you my confirmation of the meet and confer, and you can correct anything that I said.
Well done. So we're done here?
I guess. That's just something else you want to go through.
No, I'm pretty much satisfied with the outcome of this.
So you were calling to meet and confer with me about getting the bills paid and having the First Amendment complaint completed, and there was one more thing. Oh, my apparent lack of response to your requests for discovery.
The surveillance video of the October 4th, 2007 coffee burn incident.
Anything else that we met and conferred about today?
That seemed to be what that would cover it.
Okay. All right. I'll shoot you something, and you can give me a response if you think it's not accurate. Okay?
Sounds good.
All right. I look forward to speaking with you. And yeah, if you need to talk about anything, give me a call, because Edwin's off into another world working on other stuff. This case isn't his anymore.
So that one is another one disappearing from the case now, huh?
That's it, man. And you know, if I disappear from the case, there's a big problem.
So what we got the employee, what's her name? Nikisha. She's disappeared. Now what? Charla is no longer taking the phone calls. They done transferred me to someone else, and now there's Edwin's no longer on the case.
Yeah.
Okay. Wanted to make sure.
I guess that's it.
You wanted to make sure I got that right.
Okay.
Okay.
Well, I don't know about Keisha disappearing. You're telling me that. You're also telling me that Shannon isn't taking your calls. I don't know if that means she's disappeared. But all I can confirm for you is that Edwin's not going to be working the case with you anymore.
Sounds good.
Okay, Miller, give me a call if you need to. Thanks a lot.
I'm gone.